Hello everyone, my name is Tishti Sharma and I'm back with another video on the topic of the Insolvency and Bankruptcy Code Ordinance 2020. I would like to start by introducing the Insolvency and Bankruptcy Code itself, and I would like to refer to it as the IBC in this video. So the IBC was introduced in the year 2016 in India. Back then, India was in dire need of a codified legislation governing insolvency and bankruptcy, as before the IBC, insolvency proceedings would take an average of almost 5 years and would involve numerous legislations like the Companies Act, SEBI Regulations Act, and many more. Hence, the introduction of IBC not only simplified the procedure but also made the process faster, as resolutions under IBC are required to be finalized within just 6 months. IBC also shifts the focus from dissolution to resolution. This allows businesses a better chance at prospering rather than just selling off the assets for recovery of debt. This act fulfills various purposes and has solved a lot of problems for Indian businesses, like consolidating and amending all the existing insolvency laws in India, which has allowed to simplify and expedite the insolvency and bankruptcy proceedings in India. It also protects the interest of creditors, including stakeholders in a company, and helps in reviving the company in a more effective and efficient way. The IBC promotes entrepreneurship in the economy by helping the creditors get the necessary relief timely, which also allows increase of credit flow in the country. This code adopts a new and timely recovery method for the banks and other institutions, which focuses on recovery more than dissolution, allowing for the businesses to thrive. The IBC also set up an Insolvency and Bankruptcy Board of India, which focuses on maximization of the value of assets of business, hence promoting growth of the business. Let us now move on to the recent amendments that have been made to the Insolvency and Bankruptcy Code 2016. Article 123 of the Indian Constitution gives power to the President of the country, under which the President can make certain laws and pass ordinances when either of the Houses of Parliament is not in session. The main reason why the President is bestowed with this law-making power is to manage the affairs of the country efficiently during situations of financial or health emergencies. The current situation arising because of COVID-19 can be considered as a financial as well as health emergency. Hence, by the virtue of the powers vested in the President of India, the Insolvency and Bankruptcy Code Ordinance was passed by him on the 6th of June 2020. This amendment suspended operation of Sections 7, 9 and 10 of the IBC 2016 and inserted Sections 10A and 66 subclause 3 into the Insolvency and Bankruptcy Code. Out of these suspended sections, Section 7 of the IBC talked about the power that lies with financial creditors. According to this section, either a financial creditor by itself or jointly with other financial creditors or any other person on behalf of the financial creditor can file an application for initiating corporate insolvency resolution process against a corporate debtor before the adjudicating authority in case a default arises. The next suspended section is Section 9 of IBC, and it contains provisions relating to the application of initiation of corporate insolvency resolution process by operational creditor. According to this section, if the period of 10 days has expired since the delivery of the notice or invoice demanding payment under Section 8 subclause 1 of the Code, and the operational creditor has still not recovered the payment from the corporate debtor or notice of dispute under Section 8 subclause 2 of the Code, then the operational creditor has the right to file an application for initiating a corporate insolvency resolution process before the adjudicating authority. Further, the next section that was suspended by this ordinance is Section 10 of the IBC. It contained provisions for initiation of corporate insolvency resolution process by corporate applicants. According to this section, a corporate applicant may file an application for initiating a corporate insolvency resolution process with the adjudicating authority in case a corporate debtor has committed default. Moving on to the newly inserted sections, the first one is Section 10A of IBC. It has been inserted with the objective of eclipsing Sections 7, 9, and 10 for a minimum period of 6 months until further orders. This section reads as follows. Notwithstanding anything contained in Sections 7, 9, and 10, no application for initiation of corporate insolvency resolution process of a corporate debtor shall be filed for any default arising on or after 25th March 2020 for a period of 6 months or such further period not exceeding 1 year from such date as may be notified in this behalf, provided that no application shall ever be filed for initiation of corporate insolvency resolution process of a corporate debtor for the said default occurring during the said period. This simply means that Section 10A of the IBC suspends the application of Section 7, 9, and 10 of IBC for a period of minimum 6 months and maximum 1 year until further notification. Even though the ordinance was passed on 6 June 2020, it has a retrospective effect. That is, it also applies to any default occurring on or after 25th March 2020 till 6 June 2020. Therefore, any application for corporate insolvency resolution against a corporate debtor cannot be filed starting 25th March till the time period mentioned in the said amendment. To clear any further doubts arising out of this amendment, Section 10A also mentions that any default arising before 25th March 2020 will not be covered under this section. Another section that has been newly inserted through this ordinance is Section 66 Subclause 3 of IBC. The pre-existing Section 66 Subclause 2 ensured that directors or partners acted diligently in carrying out the business. Section 66 Subclause 2 imposed liability on directors or partners of a corporate debtor if they had failed to exercise due diligence in minimizing potential losses that could be incurred. However, the addition of Section 66 Subclause 3 to the Code bars the application of Section 66 Subclause 2 completely. To conclude, I would like to say that the Insolvency and Bankruptcy Code Ordinance is likely to give a big relief to debtors and companies going through a financial crisis or facing liquidity issues as well as supply chain issues. The introduction of this ordinance will buy such companies and debtors ample amount of time to get their finance back on track and to safeguard their business during the COVID-19 crisis. Thank you.